Welcome to our deep dive on whether you should hire an immigration attorney for a marriage-based green card through adjustment of status. First, we will set the stage with what the AOS process actually involves and address the core decision, DIY, versus hiring professional legal counsel. Next, we will compare scenarios where a lawyer is optional versus non-negotiable. Then, we will walk through timelines, red flags, and how to pick the right specialist. Finally, we will wrap up with key takeaways, a disclaimer, and a helpful checklist so you can confidently plan your next steps. Here is our roadmap. First, we cover the AOS basics and a typical timeline. Next, we compare DIY versus hiring counsel and clarify the division of work. Then, we highlight when an attorney is essential and why filing too quickly can be risky. After that, we explain how to choose the right specialist, discuss costs, and the remote nature of the process, and test your knowledge with short quizzes. Finally, we conclude with key takeaways and a crucial disclaimer. To begin, let's clarify the adjustment of status path through marriage to a U.S. citizen. Typically, couples file the I-130 petition and I-485 adjustment concurrently, often called a one-step or concurrent filing, with optional I-765 for work authorization and I-131 for advanced parole travel. While this looks streamlined, it comes with important nuances. Therefore, understanding the process flow and evidence expectations is critical before deciding whether to hire an attorney. Let's visualize the journey. First, marriage leads to two core filings, the I-130 to prove the qualifying relationship and the I-485 to request permanent residency. Next, biometrics are taken to complete background checks. Meanwhile, many applicants choose to apply for EAD and advance parole to work and travel while the case is pending. Then, most cases proceed to an in-person interview where a decision is made. If approved, you receive a green card. However, if more evidence is needed, you might receive a request for evidence or a notice of intent to deny. Therefore, planning your evidence from day one pays dividends by reducing delays. Now let's compare DIY and professional counsel. First, DIY offers cost savings and complete control, and it can succeed in clean, straightforward cases. However, it demands meticulous organization and carries the risk of missing nuanced evidence that can trigger RFEs. On the other hand, attorneys provide structure, curated evidence strategies, and early risk detection in timelines or status histories. However, even with counsel, you still must supply your personal documents and accurate history. Therefore, hiring a lawyer often buys peace of mind and stronger risk management, rather than freedom from doing the groundwork. Here is a realistic division of labor. First, you collect identity documents, immigration history, and joint evidence, and you write your relationship timeline. Next, the attorney transforms your materials into a coherent, strategically organized packet, maps your information to the correct forms, and spots legal risks. Meanwhile, interview preparation and potential RFE responses benefit significantly from a lawyer's experience. Therefore, even though you do most of the document collection, counsel materially improves structure, risk mitigation, and persuasive presentation. Let's discuss when legal representation becomes non-negotiable. First, if you have any prior immigration violations or gaps in status, you need counsel to evaluate risks and remedies. Next, complex transitions, such as going from F1 directly to adjustment, require careful strategy. Additionally, any history of denials, removals, or criminal issues makes legal analysis essential. Moreover, if you are racing the clock, speed increases the chance of mistakes and scrutiny. Finally, if your marriage evidence is thin or complicated, a strong attorney can design a robust evidentiary package to withstand examination. However, a major pitfall is filing too quickly after marriage. First, immediate filing without a developed evidence trail can raise concerns about the bona fide nature of the relationship. Next, rushed packets are often disorganized and light on persuasive exhibits. Therefore, a defensive legal strategy may be required to preempt RFEs or NOIDs if you intend to file early. In many cases, it is wiser to build a short documentary timeline, such as joint lease, joint bank statements, shared insurance, before submitting the adjustment package. To put timing in context, here is a typical milestone view. First, after the wedding, it is prudent to spend time building bona fide evidence and assembling forms. Next, once filed, biometrics usually occur within a few months. Meanwhile, EAD and advanced parole processing can provide work and travel flexibility during the wait. Then, interviews often occur between 6 and 18 months, varying by field office. Finally, decisions can take place shortly after the interview, though timelines vary widely. Therefore, patience and preparation are key. Quiz time. Which scenario most strongly indicates you should hire an attorney?
Option A. You have a clean history, organized documents, and ample joint evidence.
Option B. You recently married and want to file immediately with minimal evidence. Option C. You enjoy paperwork and have time to assemble forms. Option D. You live near a USCIS office and can attend interviews easily. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is: you recently married and want to file immediately with minimal evidence. Filing quickly without robust documentation can trigger scrutiny, so counsel can help frame a defensive strategy, strengthen evidence, and reduce the likelihood of RFEs or worse. Next, let's talk selection criteria. First, prioritize evidence mastery. The best attorneys know precisely what exhibits persuade officers and how to avoid RFEs. Second, choose responsiveness and clarity. You need a firm that communicates quickly and plainly about risks, timelines, and required documents. Third, insist on specialized experience. Avoid generalists and look for verifiable success in marriage-based AOS cases, including nuanced timelines and status issues. Therefore, expertise and communication quality matter more than the cheapest price tag. To reinforce these traits, here is a mind map. First, evidence mastery includes targeted checklists, tailored exhibits, and RFE avoidance. Next, responsiveness means clear explanations, timely updates, and transparent fees. Finally, specialized experience points to a focus on marriage-based AOS, handling complex timelines, and addressing prior status issues. Altogether, this profile helps you identify counsel who adds real value. Now, about location. First, because adjustment of status is a federal process, most legal tasks can be handled remotely. Next, this means you can prioritize expertise over proximity, selecting the best fit attorney nationwide. Meanwhile, secure client portals and encrypted email facilitate safe document exchange. Therefore, choose the specialist who best matches your needs, regardless of geography. Here is a simple sequence of collaboration. First, you share your history and documents with your attorney. Next, the attorney provides strategy and a checklist. Then, you assemble the evidence package, and the attorney files with USCIS. Meanwhile, USCIS issues receipts and notices. You attend biometrics, and later you receive an interview notice, if applicable. Subsequently, your attorney prepares you for the interview, you attend, and USCIS issues a decision. Therefore, well-defined handoffs keep the case on track. Let's frame costs and value. First, USCIS fees change over time, so confirm the latest amounts on the official website. Next, attorney fees vary by market and complexity. Rather than chasing the lowest price, prioritize specialization and verifiable outcomes. Meanwhile, account for translations, notary, and postage. Additionally, DIY requires significant time to learn and organize, which is an opportunity cost. Finally, the cost of mistakes can be high, including delays, RFEs, or denials. Therefore, a strong evidence strategy can be a form of insurance. Second quiz. Which factor should weigh most when selecting an immigration attorney for adjustment of status? Option A. Lowest price available. Option B. Office proximity to your home. Option C. Specialization in marriage-based AOS and evidence mastery. Option D. Fancy office and branding. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is specialization in marriage-based adjustment of status and evidence mastery. Expertise and a strong evidence strategy are what reduce delays and RFEs, providing value that outweighs superficial considerations like branding or proximity. Before you hire or file, prepare efficiently. First, draft your relationship timeline. Next, assemble identity documents, immigration records, and any prior visas or entries. Then, gather joint evidence such as leases, bank statements, taxes, and shared insurance, along with carefully selected photos. Additionally, write out your status history and flag any gaps or concerns.
Moreover, prepare questions on timing, risks, and evidence strategy.
Finally, confirm current USCIS fees and form additions on the official website so you and your attorney work from accurate information. Let's dispel a few myths using quick contrasts. First, the belief that lawyers do everything is inaccurate. You still must provide most of the content, while counsel adds structure and strategy. Next, filing immediately after the wedding is not always best. Without strong evidence, it can draw scrutiny. Moreover, local isn't inherently better because AOS is a federal process. Focus on expertise. Finally, the cheapest option may neglect evidence strategy and risk recognition, which are critical to success.
To summarize the essentials.
First, clean, well-documented cases can be handled DIY. Next, if your history is complex or you intend to file quickly, counsel is advisable. Moreover, evidence mastery is the primary value a great attorney brings. Additionally, prioritize responsiveness and specialization, not proximity. Finally, view legal fees as insurance against delays, RFEs, and potential denials. As we conclude, start by assessing your case complexity and timeline. Next, if you feel uncertain, consult a specialized AOS attorney. Meanwhile, organize your evidence early and thoroughly. Additionally, avoid rushing. Build a credible documentary trail first. Finally, verify current fees and form additions on USCIS.gov before filing so your packet is accurate and up to date. Before we finish, an important disclaimer. This video is for educational purposes only and does not create an attorney-client relationship. Immigration laws, fees, policies, and processing times change. Therefore, always seek personalized advice from a licensed immigration attorney and verify current requirements on USCIS.gov. Thank you for watching. If this video helped you clarify the DIY versus attorney decision for marriage-based AOS, please like the video, share it with someone who needs it, and subscribe for more practical immigration guides. What is your biggest AOS question or concern? Share your thoughts in the comments so we can cover them in future videos.